Hi, I'm Ed Provder, vocational expert and life care planner from Occupational Assessment Services, Inc., with offices in New York City, Lodi, Toms River, New Jersey, and Miami, Florida. For more than 35 years, OAS has been among the leading providers of expert services for plaintiff and defense attorneys. We have served as vocational experts and life care planners in some of the largest and complex cases in the United States, including the Verney versus Aramak case against Giant Stadium, which obtained a record verdict of $135 million. In 2001, we have been involved in the top 6 verdicts or settlements in New Jersey, including an $18 million settlement of a pharmaceutical executive who sustained severe physical injuries. OAS expert testimony has been accepted in numerous state and federal government courts. Our goal through the production of the following video series is to educate attorneys to assist them in understanding how vocational experts and life care planners can help them in objectively documenting the employability, earning capacity, and long-term care cost which combine to make up the damages of their case. Mistake number 1, not knowing the worth of the case. Many attorneys accept a case knowing that the injuries are serious, but are deficient in assessing the vocational and economic consequences of the case. One of the most important, difficult process performed by an attorney is evaluating a personal injury case, is making an accurate determination of the case worth. A rule that should be followed is that if the injury is permanent and does affect the injured person's ability to work, it may have a significant impact on that person's earning capacity, as this can have a direct relation to assessing the diminution of earning capacity and economic damages. Following is a representative list of the most prevalent permanent injuries which may affect a person's ability to work and therefore may indicate a case with significant value. Cervical and back injuries such as bulging or herniated discs, severe or non-union fractures of the wrist, arm, hip, or leg, amputation, cerebral palsy, carpal tunnel syndrome, brachial plexus injury, paraplegic, quadriplegic, traumatic brain injuries, visual impairments, and psychological impairments. Any of these severe impairments may affect an adult's or child's potential to obtain their fullest earning capacity and may involve an assessment of their long-term life care plan needs. The following case illustrates how a somewhat minor injury can result in a significant loss of earning capacity. Ms. Smith was a 25-year-old graphic artist with training in advertising and design. She was involved in an accident which resulted in injury to the 4th finger of her dominant right hand, which resulted in her being unable to make a fist or use the hand to write. OAS performed extensive vocational testing which demonstrated that Ms. Smith had impaired dexterity, diminished bimanual coordination, and small tool use, which negatively affected her speed, ability to perform illustrations, and affected the accuracy of her work. The OAS vocational expert concluded that based on his vocational evaluation that Ms. Smith could not perform her prior work as a graphic artist, but with her limitations could perform lower paying clerical work. The vocational expert's opinion was that Ms. Smith had sustained a $5,500 a year loss of earning capacity due to her 4th finger injury to her right hand. The case was settled for $260,000. This case illustrates the importance of relying and relating the permanency of the injury and resultant residual functional limitations to the person's pre-injury and post-injury employment to determine the case value. For further information about our vocational expert and life care planning services, please visit our website at oasinc.org or call 1-800-292-1919 for a free case proposal and a recent case verdict to assess how your damages of your case in personal injury can be affected.